And the suspect in the United Healthcare CEO killing is in court today, exactly a year after the New York City murder. Defense attorneys are trying for a third day to convince a judge not to let prosecutors use key evidence in the trial. And right now, an Altoona police officer is testifying about the arrest defense attorneys say violated the suspect's rights. ABC's legal contributor Brian Buckmeyer is here with more on that. Hi, Brian. So there are sort of 3 points of focus here, right? The arrest itself, the search of the bag, and the way that they questioned Luigi Mangione.
Absolutely. So when you're looking at it, there are 3 different, smaller hearings within this hearing. It's about the search of Luigi Mangione's person, as well as the backpack being the bigger one, statements that were given pre-Miranda, and then also identification. And so what it comes to the statements, the interesting part there is, when you talk about someone being arrested, you have to give them Miranda warnings, not because you can't arrest them because of it, because you can't use any statements against them. And if they're arrested, they're not able to leave, they're detained, they're not necessarily have handcuffs on them. So there's this gray area as to where that line is and when statements can be used and when statements can't be used. That's a big contention in this hearing right now.
The prosecution has shown a lot of body cam footage throughout this hearing. How do you think that's going to play into this?
I think the body cam video is probably the biggest part of this hearing. We saw on Tuesday, there was a break on Wednesday with the case, that the defense, Karen Agnifilo, didn't really ask a lot of questions. I know that might be somewhat surprising, but in a case like this, you're probably being more strategic and you don't want to ask too many questions of the witness because they can cure or kind of correct what might have happened in the video, give their impression as to why they thought this, like why they thought there was a bomb inside the backpack, even though there's no reason to believe that. But I think they're going to go based on the video and say, look at the video, look at the bag, look how he's detained, look how he's held. He should have been Mirandized. They should not have searched his bag without a warrant. That's our argument. Don't really get lost in the questions.
The way you describe it, it sounds very straightforward. The bag wasn't near him. It wasn't within his reach. There was no active threat at the time, and so no reason to search the bag without a warrant. But you also say that these cases are difficult to win, right? The argument that the defense is making. How do you see this playing out, and why is it such a difficult argument?
I think it's going to depend on how much the judge is going to credit the officer's own words and whether or not he's going to find that to be credible. The biggest example I can give is that we hear on body-worn camera, at least on 2 occasions, the officer mentioning that the safety of the backpack, putting it to the side, believing there might be a bomb there, either at the McDonald's or at the precinct. Now, if you take that officer's words at face value, you say, okay, there's a threat here. Search the backpack, you allow for it. That's the exigent circumstance that the law allows for you to do that. But then you go a little bit deeper and say, okay, if you thought there was a bomb there, why did you not call the bomb squad at both the McDonald's and when you brought it back to the precinct? Why didn't you do the steps that you would have done if you truly believed there was a danger within the bag? Now, where is the judge going to fall? I'm sorry, as an attorney who practices in New York, often the judge falls and says, you know what, he said he was fearful, so that's it. I'm not going to look at his actions. I'm going to look at his words. And that's why, as a defense attorney, this is so hard.
All right, Brian Buckmeyer, thank you.
My pleasure.